What is showing? That's a slide. Yeah, this is not your slide. It's this. The screen is not showing like that. It's not showing the picture. Good afternoon, ladies and gentlemen. Once again, my name is Anthony Budeze, a lawyer by profession. I welcome each and every one of you to today's lecture. And I also say Happy New Year to each and every one of us. As we already know, today's lecture is business law. We'll be talking about the registration of business in Nigeria and compliance requirements. As a matter of fact, today's business is all about business law, and at the end of the day, we have several objectives, which I believe each and every one of us must know the real essence of today's course. One, it enables the participants have a basic understanding of the nature of the Nigerian legal system in Nigeria. Two, to enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria. Three, for participants to know the types of business organizations and the step in the formation and registration of business in Nigeria. Four, understand the basic nature and elements in a commercial contract. We have several topics. One, we have the Nigerian legal system. It's a topic, policies in Nigeria. We have types of business organizations and legal implication of the various types of business organizations. Registration of business organizations, law of contract. As a matter of fact, we are going to take all these in seriatim, one after the other, starting with the Nigerian legal system. For us to commence, first of all, we have to ask ourselves a question. What is the meaning of law? As a matter of fact, law has different dimensional definition. It depends on the school of thoughts. It depends on the way you are looking at it. But as a matter of fact, law is all about principles, a body of rules, a body of principles that govern a particular circumstance. Every set of circumstances must be governed by a law, must be governed by a particular rules and regulation. That makes it a law. As a matter of fact, we have business law as what we are trying to do today. We have international law, the law that governs the transaction in international treaties and other things. We also have commercial law, law that governs commercial transactions. We have business law, the law that governs the business transaction in Nigeria. And that is the reason why I said earlier before now that law is a body of rules or principles that govern that particular circumstance. What we are dealing today is on business law. So it's all about the law that governs the registration of business, the law that governs business transaction in Nigeria. And as a matter of fact, we are going to limit ourselves to business law. Now, we talk of sources of Nigerian law. This law we are talking about, where do we derive our own law? And that's what we meant by sources of Nigerian law. We derived our law in various sources. One, the common law. What is common law? Common law means those laws evolved in the British, those British law, those old usages that evolves as a law. We call them common law. And as a matter of fact, this common law in question happens to be very, very hard, very, very harsh. And because of the harshness of the common law in the Britain, then that informed the introduction of doctrines of equity as one of the sources of Nigerian law. Doctrines of equity means it just came in with a view to mitigate the rigidity or the hardship of the common law, because then the common law was so harsh. If followed stricto sensu, it will occasion injustice on individual. And having found out that it occasion injustice on individual, then that informed the introduction of doctrines of equity. Equity has to do with fairness. Equity has to do with something being fair, and it came in with a view to moderate, with a view to mitigate the hardship, the rigidity of the common law. Then we also have Nigerian legislation as a source of Nigerian law. What do we mean by Nigerian legislation? Nigerian legislation means those laws enacted in Nigeria, it becomes a source of Nigerian law. For an instance, if the local government council promulgate or enact a law, it becomes a bylaw at that local government level. At the state level, when the state houses of assembly makes law that governs the states, it becomes law of that particular state. Then at the federal level, National Assembly, if they make law, it becomes an act. All these are what they call Nigerian legislation. And it also forms the sources of Nigerian law. We also have what they call customary law. What is customary law? Customary law is all about the custom, the people's way of life, which must be written, which is generally acceptable by that particular organization, by that particular society, to serve as the law that governs that particular society. That is customary law. And as a matter of fact, before a customary law can be recognized as a customary law, such law must be in existence, such law should also be written, and such law must not offend the principles of natural justice. It should not be repugnant to natural justice, equity, and good conscience. In other words, any law, customary law, which is repugnant to natural justice, equity, and good conscience, that customary law does not pass the test of its acceptability. And another thing is that for a law, a customary law to be obtainable, or for it to be regarded as a customary law, it must be generally accepted. It must be in existence. These are the features, and also flexibility. It must be flexible, and it also does not offend the principles of natural justice, does not offend the repugnancy text, the repugnancy doctrine, which says that any law that is repugnant to natural justice, equity, good conscience, such law does not pass. In such case, such law is not enforceable. Apart from that, judicial presence is also one of the sources of Nigerian law. What do we mean by judicial presence? Judicial presence means a situation where the lower court makes a decision, and being dissatisfied by the decision of the lower court, somebody will now appeal to an appellate court. Then the appellate court will now make a decision in respect of that. In other words, if a similar matter comes up again before the High Court for determination, in such situation, they will make reference to the decision of the appellate court. We call it judicial precedence. And also case law. Case law is also just like a case, which has received judicial attention or judicial blessing in such situation in several matters, or where we have similar cases, then you make reference to that particular case. It becomes judicial precedent and also becomes source of Nigerian law. And also international law is also source of Nigerian law. Hierarchy of courts. You have the Supreme Courts, you have the Court of Appeal, you have Federal High Courts, you have State High Courts, National Industrial Courts, Sharia Courts, Customary Courts, Magistrate Courts, Area Courts. As a matter of fact, the Supreme Court is the highest court of the land. Any decision reached by Supreme Court, that decision becomes binding. And that is what we meant by that judicial process. In other words, the subsequent courts, the lower court, will be left in option than to abide, than to comply with the rules or the rulings or the judgment of the Supreme Court, because he is the apex court. And the Court of Appeal also will definitely abide by that. Then the same thing applies to High Court. The High Court will also take decision of the Court of Appeal as a judicial president. Court of Appeal will also abide by the decision of the Supreme Court as a judicial president. So it goes down. Then we have civil law. Civil law has to do with the private rights of citizens and obligations towards each other. We have civil wrongs like defamation. You know what we mean by defamation of character, trespass, assault, passing off. And there is a distinction between the criminal law and the civil law. Criminal law has to do with criminal justice system, the one of judiciary, police, EFCC, ICPC, Ministry of Justice, Correctional Service. Crimes include money laundering, theft, murder, bribery. One should ask a question: what then is the difference between the civil and the criminal? Civil has to do with violation of human rights, as in violation of personal rights, where there is an agreement between parties and one of the parties performed his or her own obligation owed to the other party when the other party now refused or neglected to observe his own part of the obligation. In such situation, the other party who has performed his own obligation will be left with an option to either file an action in court asking that the other party has infringed on his right, the other party has breached an agreement between him and him. In such situation, we call it civil law, as against where a party commits an offense against the state, like the case of murder, the case of battery, the case of assault, criminal assault, criminal intimidation, case of malicious prosecution. All these, we call them criminal law or criminal justice system. The reason why we call it criminal is because it is an offense against the state and not an offense against an individual. And it must be written in the statute book of that particular state. And bear it in mind that what is crime in state A might be different from what is crime in state B, because it depends on the National Assembly or it depends on the State House of Assembly that enacts the law. And before one should be punished for a criminal offense, that offense allegedly committed must have been the law must have been made to that effect and the punishment defined. In a situation where there's nothing like law, no punishment, in such a situation, one cannot say that such a person has committed an offense. Before one should be said to have committed an offense, such a person must have committed an offense with respect to a law which is in existence and the punishment prescribed. Then now we'll talk of relevant regulatory agencies. As a matter of fact, we have relevant regulatory agencies with respect to business transactions in Nigeria. Like one, we have Corporate Affairs Commission, we have Federal Inland Revenue Services, FIRS, of various states, Internal Revenue Services, we have Central Bank of Nigeria, we have Asset Management Corporation of Nigeria, AMCON, we have National Agency for Food and Drug Administration and Control, NAFDAC. We have Standard Organization of Nigeria, SON. We also have Federal Capital Development Authority, FCDA, State Commissioner for Lands, Local Government Council. These are the regulatory bodies. For the purposes of this lecture, we have to take them in serious. One, we'll start by addressing the issue of Corporate Affairs Commission, CAC. CAC means Corporate Affairs Commission, and it is a body incorporated. It is a body established by the Company and Allied Matters Act, CAMA, and is started with the responsibility of registration and regulation of business and non-business organizations such as companies, business names, and incorporated trustee under Part C of Company and Allied Matters Act. Then Section 7(1) of CAMA set out the main function of the Corporate Affairs Commission to include regulation, supervision of formation, incorporation, management, winding up of companies. It regulates the supervision of the formation of the company. In other words, they have a standard, they have a procedure, they set a procedure which must be followed for you to register a company. And if such procedure is not followed, definitely the company intend to register will not be registered. Then incorporation. He also set the stricto sensu, then management and winding up of companies. Now, upon incorporation of a company, there are some certain filings which a person who incorporates a company must do. And if you fail to do that, if you fail to do as prescribed by CAMA, that's by CAMA, via the Corporate Affairs Commission, in such situation, the Corporate Affairs Commission will now invoke their winding up of company's power to wind up that particular company. And if such is done, then you don't have any remedy because you fail to do what you're supposed to do. That's the reason why they announced one interaction with view to winding up the said company. Then it also includes the power to carry out investigation into the affairs of the company if situation demands. It does not stop at registration of company, it does not stop at winding up, but from time to time, the Corporate Affairs Commission, in its utmost wisdom, will conduct what they call the investigation into the affairs of the company. If peradventure the company is registered for a particular business and the company all of a sudden deviates to another business clause or another object which is not contained in the business clause of that particular company. And in such situation, maybe if somebody briefed the CAC can now invoke that power to conduct investigation into that particular company with a view to ascertaining whether or not that company still lives up to its objection, as in the object clause, whether it's still maintained or whether it's still within the ambit of the object clause. If it's not within the ambit of the object clause, that is when the CAC will now come in, either to wind up or now look for another disciplinary measure so that the company in question will now bring itself within the confine of the object clause. Federal Inland Revenue, FRS. As we already know, FRS is in charge of the collection of and administration of federal and corporate taxes. Once a company is registered, I do advise people that the first thing you should do is to go take their documents to Federal Inland Revenue with the view to registering with Inland Revenue. And once it's registered, they will give you what they call TIN number. They register for VAT, they register for both VAT and tax. And as a matter of fact, there are some certain information people are not aware. The information is not far. The information is that once a company is registered, within 6 months of its registration, you can apply to the Federal Inland
Yeah.
Sorry for the technical error. Very sorry for that. They are still on the federal inland revenue. That's where I was before the power disrupted us. On the issue of the federal level, I had earlier said that once a company is registered, there's every need for us to take our documents to federal inland revenue with a view to obtain our tax clearance certificate and our TIN number. The reason is not far-fetched. The reason is that if you fail to do that within 6 months, when you come back to make such an application for tax, they will charge you accordingly. But if you do that within 6 months of registration of your company, then what you are going to pay is just a POL, pre-operational levy. Then, then based on that, you get your certificate without any much issues. Then, for instance, if your company is registered in a state, all you need to do, you go to state inland revenue services. They will equally give you the same package which the federal will give you, but it depends on where your company in question domicile. If the company is domiciled here in Abuja, then you can do that in Abuja. If it is in the state, you can do that. You can also make an application in order to obtain your VAT. There is a form they are going to oblige you. Once you get there, they will oblige you with a form. You will fill those forms. After you must have filled those forms, you submit at the appropriate place. Then they will give you a number. They will give you a registered payers number. Then based on that, every other thing shall follow. Then you try as much as possible to remit your VAT every month. It is remittable. And if you avoid such, it is also a criminal offense. If you avoid payment of your tax, it's also a criminal offense. All you need to do, get a qualified chartered accountant or qualified auditor who will look into your business with a view to preparing both VAT and tax returns and file accordingly in order to avoid any problem with them. As a matter of fact, they will be in better position to tell you there are some goods, there are some businesses you do, then they will now put it in a non-vatable business. In other words, you are not going to remit tax in respect of that, but there are one you do, you remit tax. There are one you do, you pay tax. There are one you do, you will not pay tax. These are within the purview of the auditors. These are within the purview of the chartered accountant who will be in better position to advise you accordingly. Now, we'll now quickly go to registration with SON. What is SON? SON means Standard Organization of Nigeria. This is a sole statutory body that is vested with the responsibility of standardizing and regulating the quality of all products in Nigeria. I'm sure you will agree with me that in a situation whereby we don't have SON, there are several people who knows what will be, some manufacturers will be producing in Nigeria. They will produce fake goods, substandard goods, and they will sell it to us, and we will consume those goods. You see, that's the reason why registration of SON is very, very important. They came in as a body with a view to regulating the quality of goods produced in Nigeria, which we believe that if not for the introduction of SON, Nigerians and other persons would have been producing substandard goods, which will not be good for our consumption. Functions of the organization: one is to investigate the quality of facilities, materials, and products in Nigeria, and establish a quality assurance system, including certification of factories, products, and laboratories, to ensure reference standards for calibration and verification of measures and measuring instruments, to compile an inventory of products requiring standardization. to foster interest in the recommendation and maintenance of acceptable standards by industry and general public. To register and regulate standard marks and specifications, to advise state, federal governments, departments on specific problems relating to standards, to advise state and federal departments of governments on specific problems relating to standards. Some also have the power of seizure, confiscation, and destruction of standards, substandard products, including power to sell off premises where defective products are manufactured or stored. This is the main reason why it is necessary that upon registration of your business name, you do well to register with some. The essence of that is that if you fail to register with some and now go ahead to produce goods which are which goods are substandard, and upon being apprehended, the person will be prosecuted. It is a criminal offense to go ahead with the manufacturing, go ahead with the production without first of all bringing such goods to a son for the purposes of regulating the standard, for the purposes of taking the inventory as to whether it requires standardization or not. That must be done because they have powers. If they catch you, definitely they are good. They have the power to see how you produce such substandard goods. And in order to avoid that, I enjoin you to do well, also do good, to get your product registered with some so that you will not have any problem with Standard Organization of Nigeria. Now, we also have a NAFDAC as a regulatory bodies. NAFDAC, as you already know, just let's think of what would have, if we can flash back, what would have been the position had it been that NAFDAC is not in place. You know that by now, most persons must have died because the rate at which some persons nowadays produce consumables without adhering strict to the rules is quite alarming. And that is the essence of the introduction of NAFDAC. Even though I'm very much aware there are some people who may do that and think they are very smart without registering with NAFDAC. But the introduction of NAFDAC has gone a long way in curbing the excesses of those persons who have the intention of engaging in such criminal acts. The fact remains that upon registration of your company, then go to NAFDAC. The essence of going there, for instance, if you are producing pure water, you take the sample, they look at the sample, tell you what and what to be done, visit your site. As usual, after they must have visited your site, check the area where such a product is produced, then give you your NAFDAC number. Then you proceed with the production. As against when some person will want to proceed without adhering strictly to the rules and regulations regarding registration with the relevant bodies. These relevant bodies are not there for that sake, but rather they are there to ensure that standards are not compromised. They are there to ensure that everything needed to be done is done for the safety of the entire public. Now we are having said so, let's come to types of business organization and the legal implication of various types of those businesses. One, we have to ask ourselves, what is a business organization? It's just like a legitimate venture with a view to making profit. I agree with you, and I'm sure you will agree with me that the essence of business is one to make profit, even though at some point you might make loss, depends on the way you plan, depends on the feasibility studies. When you do your feasibility studies very well, before you embark on the business, you do your marketing very well. The real essence of business Now, as a matter of fact, we have different types of business organization in Nigeria. We have what they call sole proprietorship. We have partnership. We also have company. And we are going to take them in seriety. One, who is a sole proprietor? A sole proprietor is that person that opens a business on his own, opens in his name, single-handedly open business. In other words, when there is profit, he takes the profit alone. When there is loss, he takes the loss alone. It has what they call unlimited liability. In other words, in an event where the business collapses, he will be personally liable. In other words, if, for instance, he sought for loan, let's say 100,000 or 200,000, as the case may be, to open up that particular business, and at the end of the day, the business collapsed. In such situation, those people that he borrowed money from, will now follow him personally, to the extent of going to his personal asset with a view to offsetting the loan, as against a situation whereby so that means I have to increase that.
Yeah.
Okay. Very sorry once again for the technical issues. Still on sole proprietorship and its legal implication, I have said earlier that sole proprietorship is all about one-man business. In a simple term, just one-man business. If there is gain in the business, it takes it alone. If there is loss, it takes it alone. If, for instance, the business collapses and he has a personal property like car houses, then he will be left with no option than to dispose those personal property in order to offset the loan, in order to offset the debt. And The business, even if it's registered with corporate affairs, is not a separate legal personality from the sole owner. The owner's personal assets and business are separable. In other words, even if the business name is registered with the Corporate Affairs Commission, they are still the same. That's still the same as against what we will see in the next company we are going to discuss now. So the bottom line of sole proprietorship is one-man business. As a man dies, the business dies naturally. If he makes profits, he takes it alone. If he makes loss, then he will be personally liable for that. Then we also have what they call partnership and its legal implication, except in the case of partners who are limited partners. General partners have unlimited liability similar to a sole proprietorship. General partners are at risk of having their personal belongings seized to offset the debt and liability of the partnership business. Except expressly agreed otherwise, profits are to be shared equally among the partners. The determination of who is a partner in a business is whether the person partakes in profit sharing or not. The facts remain that just partnership simpliciter is the same thing with sole proprietorship. In other words, if there is any, if there is a collapse, or if the business in question did not survive in such situation, those partners who are involved in the business will be held liable with a view to offsetting the debts incurred in that particular business. We also have companies and this legal implication. As a matter of course, company means it's just like a business venture that involves two or more persons who have a common knowledge, a common consensus idea with a view to incorporating a company under corporate affairs commission. So once such a company is incorporated, that company is separate, it becomes a separate body. It becomes a corporate body who is separate from the directors. In such situations, such company can be sued and be sued in its corporate name. The reason is that there's one case they call Solomon, where it says that once a company is incorporated, it closes that company with what they call legal personality. Legal personality means that that company, upon incorporation, it becomes an artificial body that can sue, just like an individual can sue somebody in court and also can be sued. Once a company is incorporated, it becomes an individual, though artificial, who can sue somebody. Maybe company borrowed you money, or a company entered into a contract with you. At the end of the day, company performed its own obligation. You failed to perform your own obligation. Because it's a company, you think he cannot sue. No, he must sue in his corporate name. He must sue in his corporate name. In that kind of arrangement, we have shareholders of the company who have limited liabilities. Limited liability means that in a situation whereby we have about 3 shareholders, the company is incorporated, the capital base of the company is 1 million share capital, then 3 persons now subscribe to the shares of that company. Let's say one 400,000, then the other one 300,000, then the other one 300,000. In such situation, if that company collapses or if there is a winding up, if things doesn't go the way it wants, or maybe the company incurs some debts, in such situation, after they must have sold the property of that particular company with a view to offsetting that particular debt, and the debt is still unsatisfied. In such situation, they will now move to those shareholders, the one of 400, the one of 300, the other one of 300. That is what they call limited liability company. Limited in the sense that those shareholders are limited to their shares in terms of winding up, in terms of payment of debt. They are only limited to that amount which they subscribed. They cannot go beyond that amount, unlike the sole proprietorship. It doesn't concern them. If you have a motor that worth millions of naira, they will sell it in order to do what offset it. But for limited liability company, those shareholders are only limited to the shares upon which they subscribe at the initial stage of the memorandum and article of association. The personal asset of the shareholder cannot be seized to offset the debts and liability of the company because he is limited to a particular amount of money. The company, being a human being of his own, can do the following in his registered name. The company, upon registration, they can buy and own properties, they can enter into contracts, they can sue somebody who breached that agreement, and they can also be sued by another person if they breach an agreement. Not they alone can sue, other person can sue them if they breach an agreement. And you also enjoy perpetual succession, that is, you lose forever. Unlike in a sole proprietorship, which I said earlier, that once that sole proprietor in question is late, is demise, is nowhere to be seen. In such situation, the business in question is late, is demise, and also is nowhere to be seen. Unlike in these companies, it enjoys perpetual succession because if Director A dies, Director B is there. If Director B dies, Director C is there. Shareholders, they are there. They put hands together. They have a meeting, what they call board of directors. They meet together with a view to moving the company forward as against when it is a sole director. Once that sole director dies, that is the end of the business. They can also apply loan for a loan in this registered name. All you need to do at the end of the day, you register a company with that company name that you register. You can use it to apply for a loan. And once a loan is applied for, they will give you a loan based on that company name and not as an individual. In other words, that company in question is separate from you as an individual. If somebody is dealing with you as an individual, the person is making a very serious mistake because your company is registered, you use the name of the company to access funds. Assuming the company failed to pay back the fund assessed or the loan in question assessed in such situation, instead of them to file action against the company and file against you, that action cannot stand the test of time. That action cannot hold water because you are a separate body, distinct from the company you registered. Why do we register our business name? The registration of business organization is the Corporate Affairs Commission, which I'm sure you must have known about that, whether be it a business name or company incorporation. Any business, whether small or large, will in the long run benefit you. You have to benefit from corporate existence of such business, physical and product registration. As a matter of fact, there's no company, there's no organization in Nigeria that want to deal with you as an individual, but rather they want to deal with you as a corporate body. For instance, if you go to make an application for job at maybe AMAC or ministry, departments, or agencies, or Ministry of Works, there's no way an award letter will be given to you in your personal capacity, but rather it will be given to you in your company name. And that is the reason why it is very, very interesting and also beneficial for you people to do what? To get your business name registered. Once it's registered, then you can do many more businesses. Unregistered business with Corporate Affairs Commission, CAC, is unknown in law and therefore cannot transact some official businesses like borrowing from a bank, while unregistered products, example, food, products with NAFDAC will attract low and limited or local patronage and may be seized and producing premises sold, resulting in huge losses. So what are we trying to say? What we are trying to say, we are encouraging you to go ahead, register a business so as to give you the good footing in making an application for loan or assessing loan, both in the ministry, department, or agency, and also give you the opportunity of doing contract, executing contracts with the Federal Ministry of Works, State Ministry of Works, and every other department that will give you such services. And what we are trying to say is that once that name is not registered, those ministry departments or agency cannot do business with you. And this is the reason why it is very, very important, very imperative that you get your business registered so that you can take advantage of all this just mentioned. Registration for tax is also an important social responsibility, both from a legal and moral angle. I had earlier on said that take the benefit once a company is registered within 6 months, take your documents to federal inland revenue or state inland revenue, as the case may be, with a view to obtaining your tax clearance certificate. If it passes 6 months, it then means that you are going to pay heavily. But if it's within the 6 months, these are the privilege, the window that you try as much as possible to speed in order not to pay much. Small business startup procedure. As you already know, all you need to do for you to start up any business procedure, find a suitable business name to support your business idea. Because once you get the business name, the name that suits you, the name you like, you can take it to Corporate Affairs Commission. That's what they call name search. They will put in an availability for name search, and if the name is available, then you now proceed with the registration of that particular name. Identify suitable location, business location, where you intend to carry on the business, then register with the FIRS and as a value-added tax, that's VAT collection point. Register your products with NAFDAC, register with SANS. Once you do all this, you are good to go. First of all, get a name, put in an availability. If the name is available, they normally reserve it for 60 days. Within that 60 days reservation, then you must have done the other necessary things, obtaining the form, fill the forms, then get your name registered, then register with FIRS, VAT and all this, with NAFDAC, then SON, and you are good to go. With all this, if you enter into an office, ministry, department, or agency with a view to obtaining loan, upon presentation of all these documents, I don't see a reason why they will not oblige you. As against somebody who comes there and asks for loan, and they'll ask you where are documentation. They say, no, you want to give it to me personally. They will know that you don't know what you're doing. I had earlier on procedure and documentation to be submitted to CAC for registration of business. Earlier on says so, one, reservation of the name, CAC portal, which is usually 60 days, submit notice of approval of name, duly completed business name application form containing the personal details of the proposed proprietors or directors, as the case may be. State the nature of the business. The nature of the business must be stated in the form they give to you. Information page of national identity card or driver, you have to oblige them with your means of identification, either driver's license, national ID card, voter's card, international passport. These are the valid means of identification and not your personal office ID card. That one is not acceptable. Then 2 passport size photographs of the proprietors or the persons in charge, evidence of payment of filing fees to CAC, examples of business names. You can just use your name, Taiwo and Taiwo, Chedi and Chedi Ventures, Cheka and Cheka Ventures, and all this. And these are the names which you can coin by yourself. You can even use your personal name, join it with your children's name, or use your personal name, join with your father's name or your son's name. Then you'll be able to make out a name and put in for a reservation. And with reserved, then you proceed from there. And the same thing applies to the procedure, applies to the same procedure for registration of company. It's the same thing. If it is a limited liability company, we normally have directors there, and those directors from 2, you understand, up to 50 shareholders. But if it's a limited liability company, it has no limitation. Yes, then public liability company are usually quoted at the stock exchange, like Zenith Bank PLC is a public limited liability company. You see, something like Dangote Sugar, all those things are public liability company, which their shares are usually quoted in the stock exchange, as against private limited liability company, which is usually for business of this kind of nature. Then the first step to take in registration is the reservation of the proposed name, which I had earlier on said. Then that notice of approval of the reserved name, and they usually reserve your name for 60 days. After that 60 days, then you can do what they call revalidation. If you're unable to meet with time, you can revalidate it. You understand? Then duly completed set of CAC incorporation form detailing the personal information of the proposed directors, shareholders. A company must have a minimum of 2 directors and 2 shareholders. Mind you, in sole proprietorship, there's nothing like directors, it's just one person who is the owner of that business. Photocopy of the information page on the national ID card, and valid means of identification, evidence of consent letter. A person who wants to be a director must put in his or her consent letter that he has consented to be a director of company A or company B. The proficiency certificate, this one is applicable in a situation whereby it is a pharmaceutical company that you want to, or medical company that you want to register. In such situation, the CAC will require what they call proficiency certificate. The essence of that is to confirm that this person who wants to register pharmaceutical company is a qualified pharmacist and not a quack. The memorandum and article associated duly stamped is paid on these 2 documents. These are the documents that when you package it very well, which lawyers normally package it for clients, when all these documents are well packaged, then you now put in. Then the next thing you wait for is your certificate of registration of the company. And you move ahead to do whatever you want to do in respect of soliciting for fund or maybe executing contracts. Then we have law of contracts as one of the topics. And for us to move on this, first of all, we'll ask ourselves, what is contract? You know, in our daily transaction, we normally say contract, agreement. What is contract? You understand? Contract is all about agreement between parties. Party may enter into an agreement with a view to doing 1 or 2 things, and for an agreement to stand, there must be terms and conditions which must be stipulated in that particular agreement. And that terms and conditions are the obligations which parties must be observed. And if party A observes the terms and conditions and party B fail to observe that, it becomes a breach. And once there is a breach, there must be an award of damages in that situation. So that's the reason why it is an enforceable legal obligation agreed upon, because parties have sat, parties have met, parties have what they call consensus ad idem, meeting of 2 minds with a view to entering into a legal relationship, with a view to entering into a contract, an enforceable legal obligation, which must be agreed upon. And as a matter of fact, we have elements, features of valid contracts. And as a matter of fact, we have what they call offer. What is an offer? Offer is just like a statement made by the offeror. Offeror is the person that's making a statement. I want to sell my car. That is a statement. And that statement made by an offer must be definite. It must proceed from the offeror. It must proceed from the offeror. That statement must be made by an offeror, and it must be definite. And that makes it an offer. Then having made such an offer to another party called an offeree, an offeree has the duty to do what? To accept it, and that's what they call acceptance as a valid contract element. Acceptance means in a situation whereby the offeror may have made a statement, I want to sell my laptop. Made a statement to the offeree, I want to sell my laptop. Then the offeree at so amount. In other words, it must be there. I want to sell my laptop at 50,000 naira. It is definite. Then the offeree will now say, I want to buy, I will accept it, or I will not accept it. Or he will not do what they call counter offer. As in say, I will accept, I will buy, but I will buy at the price of 40,000 naira. In such situation, that's what they call counter offer. But if he says I will buy at the same 50,000 naira as the case may be, then means there is a definite offer, and that definite offer is also accepted by the offering, and that makes it a valid contract. Another one is what they call consideration. The consideration means that thing that the offeree offered. Do you understand? When an offer makes an offer that I'm selling this at so amount of money, then the offeree now make payment in respect of that amount, it becomes a consideration. Consideration means that which the offeree offers, that which the offeree pays in respect of that agreement in question. In other words, for us to say there is a valid contract, there must be an offer, there must be an acceptance, there must be a consideration which must be furnished by the offering. The form and capacity, as we already know, not everybody has the right to enter into an agreement. There are some persons who are of age, there are minors. And as a matter of fact, minors are precluded from entering into a valid agreement. If you are not maybe up to 18 years, 20 years and above, in such situation, you are barred from entering into an agreement. And if he enters into such an agreement out of ignorance, that agreement is null and void when it comes to issue concerning interpretations. Then legality. Legality in the sense that there are some agreement parties can enter into an agreement to do an illegal purpose. And once a contract is tainted with illegality or immorality, in such situation, that contract is null and void. That contract is unenforceable on the grounds of its illegality or immorality. Then under Sorry again for the technical problem we observed. Uh, I've made mention of intention to create legal relationship as one of the features of a valid contract. The law of contract, how would they call privity of contracts, which is the only party who is a person who is a party to a contract can take benefit of that particular contract. That's what they call privity. If you're not a party to a contract, you will not benefit from such a contract. Terms of a contract have express and have implied terms. Express terms means when those terms and conditions are expressly stated. When it is implied, it's a situation whereby it is implied, as in it is not expressly stated, but implied that if this happened, then this will equally to make your contract express so that everything will be expressly stated. Vitiating element in a contract, invalidating a contract, when you have duress and undue influence, when you maybe enter into contract because of this, because of that, because of undue influence, or maybe because of misrepresentations, mistakes. These are the vitiating element that can vitiate that particular contract. Discharge of contract upon performance, those terms and conditions or observance of the obligations from both parties, then once again, sorry for the technical errors. Just like what I was saying, I was on discharge of a contract when we were interrupted by network. I've said about performance when those terms and conditions, when the objects are being, when the terms and conditions are being performed by either of the parties, then it's deemed to have been performed. That contract is deemed discharged. Frustration, there are some frustrating elements. Once it happens, then it frustrates that particular agreement, and that agreement is discharged. fundamental breach, terms and conditions, which is usually inserted in that agreement, that if this thing happens, then the agreement is deemed discharged. Mutual agreement, parties might even enter into a mutual understanding that if this thing happens, then the contract is discharged. So as a matter of fact, these are the discharge of contract. And certain things that can happen to ensure that the contract is discharged. Is this in the remedies? Easier slide. Oh, no. Remedies for breach of contract, we normally say that once there is a breach, there must be an award of damages. If a party A performs his own part and part B fails to perform his own part, that party that fails to do that will be, damages will be awarded against him that to compensate the other party who has performed his own part of the obligation. Then we also have what they call specific performance. Then in this situation, the other party who has failed to observe his own obligation may be asked to perform specifically as a part of remedies for breach of contract. Then we also have what they call the rectification, just like the correction to bring in line with what is obtainable. Then that is what they call rectification. Then injunction, the other party may be restrained from doing an act because he has done something as a breach of the contract. Then the person may be injuncted. That's what we call it. That's what we call injunction, which is usually from the courts, mandating the other party who is in breach to do this or not to do that. Then quantum merit, they may ask you to perform in accordance with the level upon which the other party has performed. That is the quantum merit. And finally, restriction, the act of removing of that particular act or that particular section that may take back the completion or the observance of that particular contract. These are the remedies, available remedies for breach of contracts. These are the available remedies for breach of contract. At this juncture, I wish to thank each and every one of us for having listened and say thank you very much for giving me your listening ears to attend to this lecture. Thank you very much. And as a matter of fact, if you have any question, I think we are free to put across our questions holistically. Thank you once again.
I'm wasting time. She make I turn back.
Follow there now. Follow like this. Follow like this.
Like that time, there you go see pass. No, I want to. Go like this. Go like this. Bounce out for here. You see that place? The road go.
You can interrupt it.
Okay, just having concluded the lecture, just like what I said earlier, if there is any question or if there's any way you didn't get it very well, you need clarification, please do well to ask your questions for the purposes of clarification. Thank you. Maria O. Abba. Any Donatus Abba. Any question? Any question in what we have discussed so far?
Good afternoon, sir.
Good afternoon. That's
Network.
Maria Abba, right?
Yes, sir. Thank you for the lecture. Hello, sir. Can you hear me?
Network is bad.
The network is not clear at some point, so I think some of us might fall back to the video or something, the YouTube video.
It's not that I'm hearing. I'm not. If you had said before, I didn't get you. I'm just hearing you now.
I think it's both sides though, but it's not like everything. It's like what I'm saying that some like that privy. I didn't get that part. Huh? 1 minute. Four double sheets. No pressure. Yes. Yes. It depends on where they are going. If the vehicle will collect 3,225 or 3,000, I will be the patient extra because it is our vehicle that will take them to that place. And this one, hello? Okay. Yes. Gift, Chika said her money is now 300 and she has put that again. I guess it will be good.
Okay. Hello.
Yeah.
Very sorry again for the. Very sorry again. You were saying something. You were saying something
because the network was
interrupted.
Yes, I said the network was on and off. At a point, it will pause a bit. I don't know if at that point you were talking or it's only my side. But though I said I got some from the beginning part, but we might fall back to the YouTube video.
Okay. It's okay. It's okay. Very sorry about the network. It's a network problem.
Okay.
And we'll pray that it will not be like that again. You know, you will have another course that people will take right away. We pray that we're going to do something to remedy the deficiency, the network problem.
Okay, we are taking another course.
Very sorry about that. Hello?
You said we are taking another course now.
Yes, we are taking another course. We are working on the network to ensuring that we don't experience what we experience now. It's a network problem. We sincerely apologize. We should just get ready for the another course.
Okay, sir.
Thank you.
Thank you, sir.
Yeah, thank you.
In case no comes. In case no comes.
So they have to do something so that
Not all the things were not connected.